The conclusion is clear and inescapable. A variable legis construction shows that paragraph 4 is not to be understood as one limited only to foreign loans, or other forms of financial support, and to technical assistance. There is definitely more to it than that. These are provisions permitting participation by foreign companies, requiring the President's report to Congress, and using, as yardstick, contributions based on economic growth and general welfare. These were neither accidentally inserted into the Constitution nor carelessly cobbled together by the drafters in lip service to shallow nationalism. The provisions patently have significance and usefulness in a context that allows agreements with foreign companies to include more than mere financial or technical assistance. Fifth, it is argued that Section 2 of Article 12 authorizes nothing more than a rendition of specific and limited financial service or technical assistance by a foreign company. This argument begs the question: to whom or for whom would it be rendered? Or who is being assisted? If the answer is the state, then it necessarily implies that the state itself is the one directly and solely undertaking the large-scale exploration, development and utilization of a mineral resource. So it follows that the state must itself bear the liability and cost of repaying the financing sourced from the foreign lender and or of paying compensation to the foreign entity rendering technical assistance. However, it is of common knowledge, and of judicial notice as well, that the government is and has for many years been financially strapped, to the point that even the most essential services have suffered serious curtailments, education and healthcare, for instance, not to mention judicial services, have had to make do with inadequate budgetary allocations. Thus, government has had to resort to build, operate, transfer and similar arrangements with the private sector, in order to get vital infrastructure projects built without any governmental outlay. The very recent brouhaha over the gargantuan fiscal crisis or budget deficit merely confirms what the ordinary citizen has suspected all along. After the reality check, one will have to admit the implausibility of a direct undertaking, by the state itself, of large-scale exploration, development and utilization of minerals, petroleum and other mineral oils. Such an undertaking entails not only humongous capital requirements, but also the attendant risk of never finding and developing economically viable quantities of minerals, petroleum and other mineral oils. 40. It is equally difficult to imagine that such a provision restricting foreign companies to the rendition of only financial or technical assistance to the government was deliberately crafted by the drafters of the Constitution, who were all well aware of the capital-intensive and technology-oriented nature of large-scale mineral or petroleum extraction and the country's deficiency in precisely those areas. 41 To say so would be tantamount to asserting that the provision was purposely designed to ladle the large-scale development and utilization of mineral, petroleum and related resources with impossible conditions, and to remain forever and permanently reserved for future generations of Filipinos. A more reasonable look at the Charter's plain language. Sixth, we shall now look closer at the plain language of the Charter and examining the logical inferences. The drafters chose to emphasize and highlight agreements XXX involving either technical or financial assistance in relation to foreign corporations' participation in large-scale edu. The inclusion of this clause on technical or financial assistance recognizes the fact that foreign business entities and multinational corporations are the ones with the resources and know-how to provide technical and or financial assistance of the magnitude and type required for large-scale exploration, development and utilization of these resources. The drafters, whose ranks included many academicians, economists, businessmen, lawyers, politicians and government officials, were not unfamiliar with the practices of foreign corporations and multinationals. Neither were they so naive as to believe that these entities would provide assistance without conditionalities or some quid pro quo. Definitely, as business persons well know and as a matter of judicial notice, this matter is not just a question of signing a promissory note or executing a technology transfer agreement. Foreign corporations usually require that they be given a say in the management, for instance, of day-to-day operations of the joint venture. They would demand the appointment of their own men as, for example, operations managers, technical experts, quality control heads, internal auditors or comptrollers. Furthermore, they would probably require seats on the board of directors, all these to ensure the success of the enterprise and the repayment of the loans and other financial assistance, and to make certain that the funding and the technology they supply would not go to waste. Ultimately, they would also want to protect their business reputation and bottom lines. 42. In short, the drafters will have to be credited with enough pragmatism and savvy to know that these foreign entities will not enter into such agreements involving assistance without requiring arrangements for the protection of their investments, gains and benefits. Thus, by specifying such agreements involving assistance, the drafters necessarily gave implied assent to everything that these agreements necessarily entailed, or that could reasonably be deemed necessary to make them tenable and effective, including management authority with respect to the day-to-day operations of the enterprise and measures for the protection of the interests of the foreign corporation, provided that Philippines' sovereignty over natural resources and full control over the enterprise undertaking the edu activities remain firmly in the state. Petitioners' theory deflated by the absence of closing out rules or guidelines. Seventh and final point regarding the plain language approach. One of the practical difficulties that results from it is the fact that there is nothing by way of transitory provisions that would serve to confirm the theory that the omission of the term service contract from the 1987 Constitution signaled the demise of service contracts. The framers knew at the time they were deliberating that there were various service contracts extant and in force and effect, including those in the petroleum industry. Many of these service contracts were long-term, 25 years, and had several more years to run. If they had meant to ban service contracts altogether, they would have had to provide for the termination or pre-termination of the existing contracts. Accordingly, they would have supplied the specifics and the when and how of effecting the extinguishment of these existing contracts, or at least the mechanics for determining them, and of putting in place the means to address the just claims of the contractors for compensation for their investments, lost opportunities, and so on, if not for the recovery thereof. If the framers had intended to put an end to service contracts, they would have at least left specific instructions to Congress to deal with these closing out issues, perhaps by way of general guidelines and a timeline within which to carry them out. The following are some extant examples of such transitory guidelines set forth in Article 18 of our Constitution. Section 23. Advertising entities affected by Paragraph 2, Section 11 of Article 16 of this Constitution shall have 5 years from its ratification to comply on a graduated and proportionate basis with the minimum Filipino ownership requirement therein. XXXXXXXXX. Section 25. After the expiration in 1991 of the agreement between the Republic of the Philippines and the United States of America concerning military bases, foreign military bases, troops, or facilities shall not be allowed in the Philippines except under a treaty duly concurred in by the Senate and, when the Congress so requires, ratified by a majority of the votes cast by the people in a national referendum held for that purpose, and recognized as a treaty by the other contracting state. Section 26. The authority to issue sequestration or freeze orders under Proclamation No. 3 dated March 25, 1986 in relation to the recovery of ill-gotten wealth shall remain operative for not more than 18 months after the ratification of this Constitution. However, in the national interest, as certified by the President, the Congress may extend such period. A sequestration or freeze order shall be issued only upon showing of a prima facie case. The order and the list of the sequestered or frozen properties shall forthwith be registered with the proper court. For orders issued before the ratification of this Constitution, the corresponding judicial action or proceeding shall be filed within 6 months from its ratification. For those issued after such ratification, the judicial action or proceeding shall be commenced within 6 months from the issuance thereof. The sequestration or freeze order is deemed automatically lifted if no judicial action or proceeding is commenced as herein provided. 43. It is inconceivable that the drafters of the Constitution would leave such an important matter, an expression of sovereignty as it were, indefinitely hanging in the air in a formless and ineffective state. Indeed, the complete absence of even a general framework only serves to further deflate petitioners' theory, like a child's balloon losing its air. Under the circumstances, the logical inconsistencies resulting from petitioners' literal and purely verbalegous approach to paragraph 4 of section 2 of Article 12 compel a resort to other aids to interpretation. Petitioners' posture also negated by ratio legis et anima. Thus, in order to resolve the inconsistencies, incongruities and ambiguities encountered and to supply the deficiencies of the plain language approach, there is a need for recourse to the proceedings of the 1986 Constitutional Commission. There is a need for ratio legis et anima. Service contracts not deconstitutionalized. Pertinent portions of the deliberations of the members of the Constitutional Commission, CONCOM, conclusively show that they discussed agreements involving either technical or financial assistance in the same breadth as service contracts and used the terms interchangeably. The following exchange between Commissioner J. Muir, sponsor of the provision, and Commissioner Suarez irrefutably proves that the agreements involving technical or financial assistance were none other than service contracts. The President. Commissioner J. Muir is recognized. We are still on Section 3. Mr. J. Muir. Yes, Madam President. With respect to the second paragraph of Section 3, my amendment by substitution reads, the President may enter into agreements with foreign-owned corporations involving either technical or financial assistance for a large-scale exploration, development and utilization of natural resources according to the terms and conditions provided by law. Mr. Villegas. The committee accepts the amendment. Commissioner Suarez will give the background. Mr. J. Muir. Thank you. The President. Commissioner Suarez is recognized. Mr. Suarez. Thank you, Madam President. Will Commissioner J. Muir answer a few clarificatory questions? Mr. J. Muir. Yes, Madam President. Mr. Suarez. This particular portion of the section has reference to what was popularly known before as service contracts, among other things, is that correct? Mr. J. Muir. Yes, Madam President. Mr. Suarez. As it is formulated, the President may enter into service contracts but subject to the guidelines that may be promulgated by Congress? Mr. J. Muir. That is correct. Mr. Suarez. Therefore, that aspect of negotiation and consummation will fall on the President, not upon Congress? Mr. J. Muir. That is also correct, Madam President. Mr. Suarez. Except that all of these contracts, service or otherwise, must be made strictly in accordance with guidelines prescribed by Congress? Mr. J. Muir. That is also correct. Mr. Suarez. And the gentleman is thinking in terms of a law that uniformly covers situations of the same nature? Mr. J. Muir. That is 100% correct. Mr. Suarez. I thank the Commissioner. Mr. J. Muir. Thank you very much. 44. The following exchange leaves no doubt that the Commissioners knew exactly what they were dealing with, service contracts. The President. Commissioner Gaskin is recognized. Mr. Gaskin. Commissioner J. Muir had proposed an amendment with regard to special service contracts which was accepted by the committee. Since the committee has accepted it, I would like to ask some questions. The President. Commissioner Gaskin may proceed. Mr. Gaskin. As it is proposed now, such service contracts will be entered into by the President with the guidelines of a general law on service contract to be enacted by Congress. Is that correct? Mr. Villegas. The Commissioner is right, Madam President. Mr. Gaskin. According to the original proposal, if the President were to enter into a particular agreement, he would need the concurrence of Congress. Now that it has been changed by the proposal of Commissioner J. Muir that Congress will set the general law to which the President shall comply, the President will, therefore, not need the concurrence of Congress every time he enters into service contracts. Is that correct? Mr. Villegas. That is right. Mr. Gaskin. The proposed amendment of Commissioner J. Mir is in direct contrast to my proposed amendment, so I would like to object and present my proposed amendment to the body. XXXXXXXXX. Mr. Gaskin. Yes, it will be up to the body. I feel that the general law to be set by Congress as regards service contract agreements which the President will enter into might be too general, or since we do not know the content yet of such a law, it might be that certain agreements will be detrimental to the interest of the Filipinos. This is in direct contrast to my proposal, which provides that there be effective constraints in the implementation of service contracts. So instead of a general law to be passed by Congress to serve as a guideline to the President when entering into service contract agreements, I propose that every service contract entered into by the President would need the concurrence of Congress, so as to assure the Filipinos of their interests with regard to the issue in Section 3 on all lands of the public domain. My alternative amendment, which we will discuss later, reads that the President shall enter into such agreements only with the concurrence of 2/3 vote of all the members of Congress sitting separately. XXXXXXXXX. Mr. Bengtson. The reason we made that shift is that we realized the original proposal could breed corruption. By the way, this is not just confined to service contracts but also to financial assistance. If we are going to make every single contract subject to the concurrence of Congress, which, according to the Commissioner's amendment, is the concurrence of 2/3 of Congress voting separately, then, 1, there is a very great chance that each contract will be different from another, and, 2, there is a great temptation that it would breed corruption because of the great lobbying that is going to happen. And we do not want to subject our legislature to that. Now, to answer the Commissioner's apprehension, by general law, we do not mean statements of motherhood. Congress can build all the restrictions that it wishes into that general law so that every contract entered into by the President under that specific area will have to be uniform. The President has no choice but to follow all the guidelines that will be provided by law. Mr. Gaskin. But my basic problem is that we do not know as of yet the contents of such a general law as to how much constraints there will be in it. And to my mind, although the committee's contention that the regular concurrence from Congress would subject Congress to extensive lobbying, I think that is a risk we will have to take, since Congress is a body of representatives of the people whose membership will be changing regularly, as there will be changing circumstances every time certain agreements are made. It would be best then to keep in taboo and attuned to the interest of the Filipino people, whenever the President enters into any agreement with regard to such an important matter as technical or financial assistance for a large-scale exploration, development and utilization of natural resources or service contracts. The people's elected representatives should be on top of it. XXXXXXXXX. Mr. Opal. Madam President, we do not need to suspend the session. If Commissioner Gaskin needs a few minutes, I can fill up the remaining time while he completes his proposed amendment. I just wanted to ask Commissioner J. Mir whether he would entertain a minor amendment to his amendment, and it reads as follows: the President shall subsequently notify Congress of every service contract entered into in accordance with the general law. I think the reason is, if I may state it briefly, as Commissioner Bengtson said, Congress can always change the general law later on to conform to new perceptions of standards that should be built into service contracts. But the only way Congress can do this is if there were a notification requirement from the office of the President that such service contracts had been entered into, subject then to the scrutiny of the members of Congress. This pertains to a situation where the service contracts are already entered into, and all that this amendment seeks is the reporting requirement from the office of the President. Will Commissioner J. Mir entertain that? Mr. J. Mir. I will gladly do so, if it is still within my power. Mr. Villegas. Yes, the committee accepts the amendment. XXXXXXXXX. SR. Tan. Madam President, may I ask a question? The President. Commissioner Tan is recognized. SR. Tan. Am I correct in thinking that the only difference between these future service contracts and the past service contracts under Mr. Marcos is the general law to be enacted by the legislature and the notification of Congress by the President? That is the only difference, is it not? Mr. Villegas: that is right. Sr. Tan: so those are the safeguards. Mr. Villegas: yes. There was no law at all governing service contracts before. Sr. Tan: thank you, Madam President. 45. More than mere financial and technical assistance entailed by the agreements. The clear words of Commissioner Jose N. Naito quoted below explicitly and eloquently demonstrate that the drafters knew that the agreements with foreign corporations were going to entail not mere technical or financial assistance but, rather, foreign investment and management of an enterprise involved in large-scale exploration, development and utilization of minerals, petroleum, and other mineral oils. The President. Commissioner Naito is recognized. Mr. Naito: Madam President, I have the permission of the acting floor leader to speak for only 2 minutes in favor of the amendment of Commissioner Gaskin. The President. Commissioner Naito may proceed. Mr. Naito: with due respect to the members of the committee and Commissioner J. Muir, I am in favor of the objection of Commissioner Gaskin. Madam President, I was one of those who refused to sign the 1973 Constitution, and one of the reasons is that there were many provisions in the transitory provisions therein that favored aliens. I was shocked when I read a provision authorizing service contracts while we, in this Constitutional Commission, provided for Filipino control of the economy. We are, therefore, providing for exceptional instances where aliens may circumvent Filipino control of our economy. And one way of circumventing the rule in favor of Filipino control of the economy is to recognize service contracts. As far as I am concerned, if I should have my own way, I am for the complete deletion of this provision. However, we are presenting a compromise in the sense that we are requiring a 2/3 vote of all the members of Congress as a safeguard. I think we should not mistrust the future members of Congress by saying that the purpose of this provision is to avoid corruption. We cannot claim that they are less patriotic than we are. I think the members of this commission should know that entering into service contracts is an exception to the rule on protection of natural resources for the interest of the nation, and therefore, being an exception, it should be subject, whenever possible, to stringent rules. It seems to me that we are liberalizing the rules in favor of aliens. I say these things with a heavy heart, Madam President. I do not claim to be a nationalist, but I love my country. Although we need investments, we must adopt safeguards that are truly reflective of the sentiments of the people and not mere cosmetic safeguards as they now appear in the J. Muir Amendment. Applause. Thank you, Madam President. 46. Another excerpt, featuring then Commissioner, now Chief Justice, Hilario G. Davide Jr., indicates the limitations of the scope of such service contracts. They are valid only in regard to minerals, petroleum and other mineral oils, not to all natural resources. The President. Commissioner Davide is recognized. Mr. Davide. Thank you, Madam President. This is an amendment to the J. Muir Amendment and also to the Opal Amendment. I propose to delete natural resources and substitute it with the following: minerals, petroleum and other mineral oils. On the Opal Amendment, I propose to add, the notification to Congress shall be within 30 days from the execution of the service contract. The President. What does the committee say with respect to the First Amendment in lieu of natural resources? Mr. Villegas. Could Commissioner Davide explain that? Mr. Davide. Madam President, with the use of natural resources here, it would necessarily include all lands of the public domain, our marine resources, forests, parks and so on. So we would like to limit the scope of these service contracts to those areas really where these may be needed, the exploitation, development and exploration of minerals, petroleum and other mineral oils. And so, we believe that we should really, if we want to grant service contracts at all, limit the same to only those particular areas where Filipino capital may not be sufficient, and not to all natural resources. Mr. Suarez. Just a point of clarification again, Madam President. When the Commissioner made those enumerations and specifications, I suppose he deliberately did not include agricultural land. Mr. Davide. That is precisely the reason we have to enumerate what these resources are into which service contracts may enter. So, beyond the reach of any service contract will be lands of the public domain, timberlands, forests, marine resources, fauna and flora, wildlife and national parks. 47. After the J. Muir Amendment was voted upon and approved by a vote of 21 to 10 with 2 abstentions, Commissioner Davide made the following statement, which is very relevant to our quest. The President. Commissioner Davide is recognized. Mr. Davide. I am very glad that Commissioner Padilla emphasized minerals, petroleum and mineral oils. The Commission has just approved the possible foreign entry into the development, exploration and utilization of these minerals, petroleum and other mineral oils by virtue of the J. Muir Amendment. I voted in favor of the J. Muir Amendment because it will eventually give way to vesting in exclusively Filipino citizens and corporations wholly owned by Filipino citizens the right to utilize the other natural resources. This means that as a matter of policy, natural resources should be utilized and exploited only by Filipino citizens or corporations wholly owned by such citizens. But by virtue of the J. Muir Amendment, since we feel that Filipino capital may not be enough for the development and utilization of minerals, petroleum and other mineral oils, the President can enter into service contracts with foreign corporations precisely for the development and utilization of such resources. And so, there is nothing to fear that we will stagnate in the development of minerals, petroleum and mineral oils because we now allow service contracts. XXX. 48. The foregoing are mere fragments of the framers' lengthy discussions of the provision dealing with agreements XXX involving either technical or financial assistance, which ultimately became paragraph 4 of Section 2 of Article 12 of the Constitution. Beyond any doubt, the members of the CONCOM are actually debating about the martial law-era service contracts for which they were crafting appropriate safeguards. In the voting that led to the approval of Article 12 by the CONCOM, the explanations given by Commissioners Gaskin, Garcia and Taddeo indicated that they had voted to reject this provision on account of their objections to the constitutionalization of the service contract concept. Mr. Gaskin said, I felt that if we would constitutionalize any provision on service contracts, this should always be with the concurrence of Congress and not guided only by a general law to be promulgated by Congress. 49 Mr. Garcia explained, service contracts are given constitutional legitimization in Sec. 3, even when they have been proven to be inimical to the interests of the nation, providing, as they do, the legal loophole for the exploitation of our natural resources for the benefit of foreign interests. 50 Likewise, Mr. Taddeo cited inter alia the fact that service contracts continued to subsist, enabling foreign interests to benefit from our natural resources. 51 It was hardly likely that these gentlemen would have objected so strenuously, had the provision called for mere technical or financial assistance and nothing more. The deliberations of the CONCOM and some commissioners' explanation of their votes leave no room for doubt that the service contract concept precisely underpinned the commissioners' understanding of the agreements involving either technical or financial assistance. Summation of the CONCOM deliberations. At this point, we sum up the matters established, based on a careful reading of the CONCOM deliberations, as follows. In their deliberations on what was to become paragraph 4, the framers used the term service contracts in referring to agreements XXX involving either technical or financial assistance. They spoke of service contracts as the concept was understood in the 1973 Constitution. It was obvious from their discussions that they were not about to ban or eradicate service contracts. Instead, they were plainly crafting provisions to put in place safeguards that would eliminate or minimize the abuses prevalent during the marital law regime. In brief, they were going to permit service contracts with foreign corporations as contractors, but with safety measures to prevent abuses, as an exception to the general norm established in the first paragraph of Section 2 of Article 12. This provision reserves or limits to Filipino citizens, and corporations at least 60% of which is owned by such citizens, the exploration, development and utilization of natural resources. This provision was prompted by the perceived insufficiency of Filipino capital and the felt need for foreign investments in the use of minerals and petroleum resources. The framers for the most part debated about a sort of safeguards that would be considered adequate and reasonable. But some of them, having more radical leanings, wanted to ban service contracts altogether. For them, the provision would permit aliens to exploit and benefit from the nation's natural resources, which they felt should be reserved only for Filipinos. In the explanation of their votes, the individual commissioners were heard by the entire body. They sounded off their individual opinions, openly enunciated their philosophies, and supported or attacked the provisions with fervor. Everyone's viewpoint was heard. In the final voting, the article on the national economy and patrimony, including paragraph 4 allowing service contracts with foreign corporations as an exception to the general norm in paragraph 1 of section 2 of the same article, was resoundingly approved by a vote of 32 to 7, with 2 abstentions. Agreements involving technical or financial assistance are service contracts with safeguards. From the foregoing, we are impelled to conclude that the phrase agreements involving either technical or financial assistance, referred to in paragraph 4, are in fact service contracts. But unlike those of the 1973 variety, the new ones are between foreign corporations acting as contractors on the one hand, and on the other, the government as principal or owner of the works. In the new service contracts, the foreign contractors provide capital, technology and technical know-how, and managerial expertise in the creation and operation of large-scale mining, extractive enterprises, and the government, through its agencies, MGB, actively exercises control and supervision over the entire operation. Such service contracts may be entered into only with respect to minerals, petroleum and other mineral oils. The grant thereof is subject to several safeguards, among which are these requirements. 1. The service contract shall be crafted in accordance with a general law that will set standard or uniform terms, conditions and requirements, presumably to attain a certain uniformity in provisions and avoid their possible insertion of terms disadvantageous to the country. 2. The President shall be the signatory for the government because, supposedly before an agreement is presented to the President for signature, it will have been vetted several times over at different levels to ensure that it conforms to law and can withstand public scrutiny. 3. Within 30 days of the executed agreement, the President shall report it to Congress to give that branch of government an opportunity to look over the agreement and interpose timely objections, if any. Use of the record of the CONCOM to ascertain intent. At this juncture, we shall address, rather than gloss over, the use of the framers' intent approach, and the criticism hurled by petitioners who quote the ruling of this court. While it is permissible in this jurisdiction to consult the debates and proceedings of the Constitutional Convention in order to arrive at the reason and purpose of the resulting Constitution, resort thereto may be had only when other guides fail, as said proceedings are powerless to vary the terms of the Constitution when the meaning is clear. Debates in the Constitutional Convention are of value as showing the views of the individual members, and as indicating the reason for their votes, but they give us no light as to the views of the large majority who did not talk, much less the mass of our fellow citizens whose votes at the polls gave that instrument the force of fundamental law. We think it safer to construe the Constitution from what appears upon its face. The proper interpretation therefore depends more on how it was understood by the people adopting it than in the framers' understanding thereof. 52. The notion that the deliberations reflect only the views of those members who spoke out and not the views of the majority who remained silent should be clarified. We must never forget that those who spoke out were heard by those who remained silent and did not react. If the latter were silent because they happened not to be present at the time, they are presumed to have read the minutes and kept abreast of the deliberations. By remaining silent, they are deemed to have signified their assent to and/or conformity with at least some of the views propounded or their lack of objections thereto. It was incumbent upon them, as representatives of the entire Filipino people, to follow the deliberations closely and to speak their minds on the matter if they did not see eye to eye with the proponents of the draft provisions. In any event, each and every one of the commissioners had the opportunity to speak out and to vote on the matter. Moreover, the individual explanations of votes are on record, and they show where each delegate stood on the issues. In sum, we cannot completely denigrate the value or usefulness of the record of the CONCOM, simply because certain members chose not to speak out. It is contended that the deliberations therein did not necessarily reflect the thinking of the voting population that participated in the referendum and ratified the Constitution. Verily, whether we like it or not, it is a bit too much to assume that every one of those who voted to ratify the proposed charter did so only after carefully reading and mulling over it, provision by provision. Likewise, it appears rather extravagant to assume that every one of those who did in fact bother to read the draft charter actually understood the import of its provisions, much less analyzed it vis-à-vis the previous constitutions. We believe that in reality, a good percentage of those who voted in favor of it did so more out of faith and trust. For them, it was the product of the hard work and careful deliberation of a group of intelligent, dedicated and trustworthy men and women of integrity and conviction, whose love of country and fidelity to duty could not be questioned. In short, a large proportion of the voters voted yes because the drafters, or a majority of them, endorsed the proposed constitution. What this fact translates to is the inescapable conclusion that many of the voters in the referendum did not form their own isolated judgment about the draft charter, much less about particular provisions therein. They only relied or fell back and acted upon the favorable endorsement or recommendation of the framers as a group. In other words, by voting yes, they may be deemed to have signified their voluntary adoption of the understanding and interpretation of the delegates with respect to the proposed charter and its particular provisions. If it's good enough for them, it's good enough for me, or, in many instances, if it's good enough for President Cory Aquino, it's good enough for me. And even for those who voted based on their own individual assessment of the proposed charter, there is no evidence available to indicate that their assessment or understanding of its provisions was in fact different from that of the drafters. This unwritten assumption seems to be petitioners as well. For all we know, this segment of voters must have read and understood the provisions of the Constitution in the same way the framers had, an assumption that would account for the favorable votes. Fundamentally speaking, in the process of rewriting the charter, the members of the CONCOM as a group were supposed to represent the entire Filipino people. Thus, we cannot but regard their views as being very much indicative of the thinking of the people with respect to the matters deliberated upon and to the charter as a whole. It is therefore reasonable and unavoidable to make the following conclusion, based on the above arguments. As written by the framers and ratified and adopted by the people, the Constitution allows the continued use of service contracts with foreign corporations, as contractors who would invest in and operate and manage extractive enterprises, subject to the full control and supervision of the state, sans the abuses of the past regime. The purpose is clear, to develop and utilize our mineral, petroleum and other resources on a large scale for the immediate and tangible benefit of the Filipino people. In view of the foregoing discussion, we should reverse the decision of January 27, 2004, and in fact now hold a view different from that of the decision, which had these findings. A. Paragraph 4 of Section 2 of Article 12 limits foreign involvement in the local mining industry to agreements strictly for either financial or technical assistance only. B. The same paragraph precludes agreements that grant to foreign corporations the management of local mining operations, as such agreements are purportedly in the nature of service contracts as these were understood under the 1973 Constitution. C. These service contracts were supposedly deconstitutionalized and proscribed by the omission of the term service contracts from the 1987 Constitution. D. Since the WMCP contains provisions permitting the foreign contractor to manage the concern, the said FTA is invalid for being a prohibited service contract, and e. provisions of RA 7942 and DOW 9640, which likewise grant managerial authority to this foreign contractor, are also invalid and unconstitutional. Ultimate test, states control. Determinative of constitutionality. But we are not yet at the end of our quest. Far from it. It seems that we are confronted with a possible collision of constitutional provisions. On the one hand, Paragraph 1 of Section 2 of Article 12 explicitly mandates the state to exercise full control and supervision over the exploration, development and utilization of natural resources. On the other hand, Paragraph 4 permits safeguarded service contracts with foreign contractors. Normally, pursuant thereto, the contractors exercise management prerogatives over the mining operations and the enterprise as a whole. There is thus a legitimate ground to be concerned that either the state's full control and supervision may rule out any exercise of management authority by the foreign contractor, or, the other way around, allowing the foreign contractor full management prerogatives may ultimately negate the state's full control and supervision. Ut magis valt quam puret. Under the third principle of constitutional construction laid down in Francisco, ut magis valt quam puret, every part of the Constitution is to be given effect, and the Constitution is to be read and understood as a harmonious whole. Thus, full control and supervision by the state must be understood as one that does not preclude the legitimate exercise of management prerogatives by the foreign contractor. Before any further discussion, we must stress the primacy and supremacy of the principle of sovereignty and state control and supervision over all aspects of exploration, development and utilization of the country's natural resources, as mandated in the first paragraph of Section 2 of Article 12. But in the next breath we have to point out that full control and supervision cannot be taken literally to mean that the state controls and supervises everything involved, down to the minutest details, and makes all decisions required in the mining operations. This strained concept of control and supervision over the mining enterprise would render impossible the legitimate exercise by the contractors of a reasonable degree of management prerogative and authority necessary and indispensable to their proper functioning. For one thing, such an interpretation would discourage foreign entry into large-scale exploration, development and utilization activities, and result in the unmitigated stagnation of this sector, to the detriment of our nation's development. This scenario renders paragraph 4 inoperative and useless. And as respondents have correctly pointed out, the government does not have to micromanage the mining operations and dip its hands into the day-to-day affairs of the enterprise in order for it to be considered as having full control and supervision. The concept of Control 53 adopted in Section 2 of Article 12 must be taken to mean less than dictatorial, all-encompassing control, but nevertheless sufficient to give the state the power to direct, restrain, regulate and govern the affairs of the extractive enterprises. Control by the state may be on a macro level, through the establishment of policies, guidelines, regulations, industry standards and similar measures that would enable the government to control the conduct of affairs in various enterprises and restrain activities deemed not desirable or beneficial. The end in view is ensuring that these enterprises contribute to the economic development and general welfare of the country, conserve the environment, and uplift the well-being of the affected local communities. Such a concept of control would be compatible with permitting the foreign contractor sufficient and reasonable management authority over the enterprise it invested in order to ensure that it is operating efficiently and profitably, to protect its investments and to enable it to succeed. The question to be answered, then, is whether RA 7942 and its implementing rules enabled the government to exercise that degree of control sufficient to direct and regulate the conduct of affairs of individual enterprises and restrain undesirable activities. On the resolution of these questions will depend the validity and constitutionality of certain provisions of the Philippine Mining Act of 1995, RA 7942, and its implementing rules and regulations, DOW 9640, as well as the WMC PFTA. Indeed, petitioners charge 54 that Law 7942, as well as its implementing rules and regulations, makes it possible for FTA contracts to cede full control and management of mining enterprises over to fully foreign-owned corporations, with the result that the state is allegedly reduced to a passive regulator dependent on submitted plans and reports, with weak review and audit powers. The state does not supposedly act as the owner of the natural resources for and on behalf of the Filipino people. It practically has little effective say in the decisions made by the enterprise. Petitioners then conclude that the law, the implementing regulations, and the WMCP cede beneficial ownership of the mineral resources to the foreign contractor. A careful scrutiny of the provisions of Law 7942 and its implementing rules belies petitioners' claims. Paraphrasing the Constitution, Section 4 of the statute clearly affirms the state's control thus. Sec. 4. Ownership of mineral resources. Mineral resources are owned by the state and the exploration, development, utilization and processing thereof shall be under its full control and supervision. The state may directly undertake such activities or it may enter into mineral agreements with contractors. The state shall recognize and protect the rights of the indigenous cultural communities to their ancestral lands as providing for by the Constitution. The aforequoted provision is substantively reiterated in Section 2 of DOW 9640 as follows. Sec. 2. Declaration of Policy. All mineral resources in public and private lands within the territory and exclusive economic zone of the Republic of the Philippines are owned by the state. It shall be the responsibility of the state to promote the rational exploration, development, utilization and conservation through the combined efforts of the government and private sector in order to enhance national growth in a way that effectively safeguards the environment and protects the rights of affected communities. Sufficient control over mining operations vested in the state. By Law 7942 and DOW 9640. Law 7942 provides for the state's control and supervision over mining operations. The following provisions thereof establish the mechanism of inspection and visitorial rights over mining operations and institute repertorial requirements in this manner. 1. Sec. 8 which provides for the DENR's power of overall supervision and periodic review for the conservation, management, development and proper use of the state's mineral resources. 2. Sec. 9 which authorizes the Mines and Geosciences Bureau, MGB, under the DENR to exercise direct charge in the administration and disposition of mineral resources, and empowers the MGB to monitor the compliance by the contractor of the terms and conditions of the mineral agreements, confiscate surety and performance bonds, and deputize whenever necessary any member or unit of the Phil. National Police, Barangay, duly registered non-governmental organization, NGO, or any qualified person to police mining activities. 3. Sec. 66 which vests in the regional director exclusive jurisdiction over safety inspections of all installations, whether surface or underground, utilized in mining operations. 4. Sec. 35, which incorporates into OFTAs the following terms, conditions and warranties. G. Mining operations shall be conducted in accordance with the provisions of the Act and its IRR. H. Work programs and minimum expenditures commitments. XXXXXXXXX. K. Requiring proponent to effectively use appropriate anti-pollution technology and facilities to protect the environment and restore or rehabilitate mined-out areas. L. The contractors shall furnish the government records of geologic, accounting and other relevant data for its mining operation, and that books of accounts and records shall be open for inspection by the government. XXX. M. Requiring the proponent to dispose of the minerals at the highest price and more advantageous terms and conditions. N. XXXXXXXXX. O. Such other terms and conditions consistent with the Constitution and with this Act as the Secretary may deem to be for the best interest of the state and the welfare of the Filipino people. The foregoing provisions of Section 35 of RA 7942 are also reflected and implemented in Section 56, G, H, L, M, and N, of the Implementing Rules, Down 9640. Moreover, RA 7942 and Down 9640 also provide various stipulations confirming the government's control over mining enterprises. The contractor is to relinquish to the government those portions of the contract area not needed for mining operations and not covered by any declaration of mining feasibility. Section 35E, RA 7942, Section 60, Down 9640. The contractor must comply with the provisions pertaining to mine safety, health and environmental protection, Chapter 11, RA 7942, Chapters 15 and 16, Down 9640. For violation of any of its terms and conditions, government may cancel NFTA. Chapter 17, RA 7942, Chapter 24, Down 9640. NFTA contractor is obliged to open its books of accounts and records for inspection by the government, Section 56 meter, Down 9640. NFTA contractor has to dispose of the minerals and byproducts at the highest market price and register with the MGB a copy of the sales agreement, Section 56N, Down 9640. MGB is mandated to monitor the contractor's compliance with the terms and conditions of the FTA, and to deputize, when necessary, any member or unit of the Philippine National Police, the barangay or an accredited non-governmental organization to police mining activities, Section 7D and F, Down 9640. NFTA cannot be transferred or assigned without prior approval by the President, Section 40, RA 7942, Section 66, Down 9640. Mining project under NFTA cannot proceed to the construction/development/utilization stage, unless its declaration of mining project feasibility has been approved by government, Section 24, RA 7942. The declaration of mining project feasibility filed by the contractor cannot be approved without submission of the following documents. 1. Approved mining project feasibility study, Section 53D, Down 9640. 2. Approved 3-year work program, Section 53A4, Down 9640. 3. Environmental compliance certificate, Section 70, RA 7942. 4. Approved Environmental Protection and Enhancement Program, Section 69, RA 7942. 5. Approval by the Sangguniang Panlalagan/Bayan/Barangay, Section 70, RA 7942, Section 27, RA 7160. 6. Free and prior informed consent by the indigenous peoples concerned, including payment of royalties through a Memorandum of Agreement, Section 16, RA 7942, Section 59, RA 8371. The FTA contractor is obliged to assist in the development of its mining community, promotion of the general welfare of its inhabitants, and development of science and mining technology, Section 57, RA 7942. The FTA contractor is obliged to submit reports, on quarterly, semi-annual or annual basis as the case may be, per Section 270, Down 9640, pertaining to the following. 1. Exploration. 2. Drilling. 3. Mineral resources and reserves. 4. Energy consumption. 5. Production. 6. Sales and marketing. 7. Employment. 8. Payment of taxes, royalties, fees and other government shares. 9. Mine safety, health and environment. 10. Land use. 11. Social development. 12. Explosives consumption. And FTA pertaining to areas within government reservations cannot be granted without written clearance from the government agencies concerned, Section 19, RA 7942, Section 54, Down 9640. And FTA contractor is required to post a financial guarantee bond in favor of the government in an amount equivalent to its expenditures obligations for any particular year. This requirement is apart from the representations and warranties of the contractor that it has access to all the financing, managerial and technical expertise and technology necessary to carry out the objectives of the FTA, Section 35B, E, and F, RA 7942.